Hello, I'm Guy Messick with the law firm of Messick and Lauer, and General Counsel to the CUSO, the National Association of Credit Union Service Organizations. This is a discussion of the issues in expanding the ownership of an existing CUSO. As CUSOs enter the mature phase of the business cycle, their credit union owners have realized that they need to grow or they will wither away. Other credit union owners see new opportunities that they want to pursue through the CUSO, and they need the partners and capital to do so. Whatever the reason, many credit union owners are deciding to expand the ownership of their CUSOs. In deciding whether to expand ownership, the first step is to determine your goal. If it's to bring in new capital, do you have a plan to use the capital? Taking in capital entails a responsibility to use the capital in a productive manner. A business plan will lay out the use of that capital. If the expansion is to attract and retain good credit union partners who will also be stickier clients of the CUSO, then the selection of good partners is essential. Usually the goals will involve both capital and client expansion. Remember that all money is not green. If the new partners are not compatible with your credit union, the costs of taking them on will far outweigh the benefits of their capital contribution. Take time to find good partners whom you trust to keep their commitments and share your vision. The mechanics of the offering is straightforward. For our discussion, we will assume the CUSO is a limited liability company. You will need a business plan for 3 to 5 years, a revised operating agreement, a subscription agreement, a sample NCUA required attorney opinion letter, a sample services agreement between the CUSO and the credit union as the client, and any employment agreements with the CUSO employees. In most cases, I also recommend a private placement memorandum setting forth the terms of the offering and the investment risk. The offering should indicate the ability of the CUSO to modify or extend the terms of the offering. You will need to decide upon the total offering amount, the unit price, and the time frame for the solicitation. The business plan should be tied into the total offering amount. Some CUSOs seek professional assistance through their accountants or an industry expert to set a price. Some back into it by the capital needs, and some just set the price by what they think the market will bear. Usually there is a premium over the initial unit price paid by the founders if the CUSO is a profitable, ongoing operation. Most solicitations are not open-ended, but have a time limitation. The time limitation serves several purposes. First, it provides a time limit for credit unions to make a decision. We all know how credit unions can procrastinate. Having said that, though, the time limit should not be too short, as the credit unions will have to have time to take their investment offering to their boards for approval. Second, you do not want the unit price to be stagnant without an opportunity to review and modify the price over time. Third, you want to have a definite time set to use the proceeds of the solicitation to meet the business plan. If the solicitation is undersubscribed after the end of the solicitation period, you will want to reevaluate the terms of the solicitation or the feasibility of the business plan. If you change the business plan because the subscription is undersubscribed, you will have to obtain the permission of the investors to proceed with the revised plan, because they invested with an understanding that the business plan presented to them was the one to be implemented. The safest course of action is not to use the proceeds of the solicitation until the subscription is fully subscribed, because if you use the investments as they come in, you run the risk of a very unhappy investor if the subscription is not filled and the business plan is not implemented after you've spent the investor's money. You also have the issue of that the early investors' capital accounts are being depleted more rapidly in comparison with the newer owners. Now, there are means to deal with these disparities, but you need to be aware of the issues in order to deal with them. The operating agreement will set forth the rights of the new investors. It will indicate whether the new investors are buying units of the same class as the founding owners or a different class of units with different rights. For example, the agreement will state who can serve on the board of managers and who can vote for or appoint managers to the board. The agreement will provide how it's to be modified, how new owners are added, how profits and losses are shared, and how new capital is raised. If the premise of the CUSO is that the owners must also be users, then the operating agreement should also indicate that an owner must also be a user of the services, and if the owner fails to continue to use those services, it is cause to involuntarily disassociate that owner from the CUSO. I recommend that in all cases where an owner disassociates, the owner is paid its net capital without interest over a number of years. This provision reduces the stress on the CUSO's capital and cash flow, and also reduces the disputes from the disassociating owners. While not typical, sometimes there is an expectation by the owners that the CUSO investment will appreciate in value, in which case there may be a need to set up a method to establish fair market value. Make sure all owners understand and mutually agree to the service goals and financial goals of the CUSO up front. It will avoid a lot of problems later. Taking time to consider your ultimate goals for your CUSO and the consequences of your current action on those goals will enable you to stay on plan and find the right partners to take your CUSO to the next level of development. I hope you found this video helpful. I invite you to view our other presentations. Thank you.